Welcome to our ninth session. This is the ninth of our seminars. We have still 4 to go. Today, we are going to cover digital markets, competition enforcement in digital markets. And again, we have 2 presentations. First will be a general one. As you can see, recent developments in competition policy on digital markets in the EU and Germany. So it's a comparative one, not Turkish one. I hope that we ask questions and clarify the issues and the differences between Turkey and the other jurisdictions. And the second one will involve personalized pricing, yes, and that will be held in Turkish, and the first one will be in English. That's why I'm talking in English. And I'd like to welcome Dr. Käseberg for coming here. Thank you for being with us today. I'd like to introduce him first to you. Let me just read from here. Dr. Thorsten Käseberg is a lawyer and economist, and he has been serving as a civil servant since 2007 in different functions in the area of economic policy. He currently has the units of competition and consumer policy in the German Federal Ministry for Economic Affairs and Energy. I hope that's still the same. I think sustainability is
climate action instead of energy.
Okay.
But we change it every 4 years. So
all right. Well, this was okay. One focus of his work is the digital transformation and its potential and challenges for regulation. He is also an official of the European Commission, currently on leave, currently on leave, where he served in the Director General for Competition between 2009 and 11. He's also a lecturer at Humboldt University. Still that?
No, I moved a bit to London in that regard.
To London, okay. And London?
School of Economics.
School of Economics. Okay, all right, great. So, your book is about intellectual property, antitrust, and cumulative innovation in the EU and the US. That was published from Hart Publishing in 2012.
A long time ago, yeah.
Still very topic. Okay, so we are hosting him today. I'd like to thank him for coming here. It's a pleasure for us to have you. And we have 40 minutes with your presentation. And after that, we'll have Q&A, like 10 minutes or 15 minutes. Floor is yours. Thank you very much.
Thanks from my side. Really, I'm extremely grateful to be here. It's really an honor and pleasure to talk to you. I already told some of you that we have a good exchange from Germany with EU member states, also with the US. But Turkey so far has not been on, let's say, our map. And that's why I'm also, of course, personally getting to know you, getting to know your topics and questions, really trying to bridge that and sort of start a bit of the conversation. So many thanks to you.
I believe that we're going to make a good Gedankenaustausch. Is that correct?
That's absolutely perfect. Yeah, absolutely.
I would like to thank also Fredrik Neumann Foundation for funding this visit. Thank you very much.
Yeah.
Please, the floor is yours.
No, I mean, that's just to tell you a bit about our role back in Berlin, as you said, in the Federal Ministry for Economic Affairs and Climate Action. Competition policy has always been ranking quite high in terms of economic policy in Germany, at least after the end of the Second World War. The concept of social market economy is really tied closely also to strong competition policy principles. So that's why our work in this ministry, except from changing titles, is really I'd say one of the core policies also today. What we do is we draft and prepare the legislation, so amendments to the German Competition Act, and then, of course, send it into the ministerial discussion and also into the German parliament. So that's one side of our work. And the other side is we are at the table when it comes to EU negotiations. I will touch upon a couple of topics. So as you said rightly, this is a very generic title. I know that some of you are top competition specialists, others maybe are, let's say, looking into it, interested, and then I'll try to bridge that a bit. A second role, and that's what I just say to thank again, is I lecture a bit in London. So thanks to Dilan, who made the connection back in London. Thanks to where I see Dennis for all the organization, Jem for hosting me today, and again the Friedrich Naumann Foundation. I'd say, which is a bit connected, if I may say, to the Liberal Party back in Germany, and maybe I'll talk a bit about that when I present the recent amendments on competition, so liberalism, competition, and the fundamental questions. Now, my plan for tonight was first give you a very broad overview, also into non-digital, but of course also digital issues that are discussed right now in the European Union. And then really move on into the also competition policy discussions that have taken place over, I'd say, the last 10 years that have sort of pre-shaped the political space for, and that's then one a core chunk of what I will present, the EU Digital Markets Act, as well as the latest amendments to the German law, so the German Act against restraints of competition. And then in the end, to ask, well, throw up maybe raise some questions also regarding the differences between German and EU law, and maybe also to relate back to developments here back in Turkey and to Turkish law and policy and enforcement. So really to outline to you what's currently discussed in Berlin, in Brussels. I'd say one of the big discussions, a meta discussion that has been going on and underlying also the development towards the Digital Markets Act is has the more economic approach in competition policy. So what the EU did like 15 years ago, really trying to take over from US, in particular, US antitrust policy to use more economic models, more economic thinking in concrete cases, whether this more economic approach has really delivered good results, or, and that's the big question I will raise more thoroughly later on, whether it has also to some extent limited the ability of competition authorities to enforce competition law on very dynamic markets that rapidly evolve in the frame of months and 1 to 3 years. So if you are following the European discussion on the enforcement of Article 102 of the treaty, so the abuse of a dominant position, the Commission has said that it will present a draft new Article 102 guidelines over the summer for discussion with stakeholders. And what you will very probably see in these guidelines is maybe not like a rupture or a clear-cut break, but clearly a development away from what you've seen previously. The Commission itself titles this approach as workable approach to Article 102. So the debate has really shifted back. There was really a time when we thought we have moved on from just looking into power, but really pinning down and requiring an authority to show a concrete harm, not only a dominant position, but really an abuse of a dominant position, and not only an abuse, but an exclusionary abuse with a concrete theory of harm. And that kind of thinking has become has really become under pressure, because politicians, politics has felt that competition policy has failed to deliver results on digital markets, on big tech. Another dimension of this debate is, if you are interested into economics, that's a bit the flip side. The relation of concentration of markets to other macro variables, like income distribution, wealth distribution, employment. If you follow that kind of debate, I'm sure you've seen many articles over the last, let's say, 5, 6, 7 years, also from very good economists trying to pin down those debates for the US, also for the EU. I have to be frank, I don't know the exact debate and numbers for Turkey. So in that regard, competition policy, which of course is the prime or first policy that you think about when you address the topic of concentration, has become political again to some extent. Then another dimension of the more economic approach debate is the complexity of procedures. Again, I have to repeat, I do not know a lot about Turkish competition law and enforcement, but I guess it's also a mature competition market with law firms, with the economists, and with nowadays in AI-generated drafts and tons of data that go into competition proceedings. And therefore, right now, we see a debate, at least I'd say in Brussels, but also in Bonn, where our competition authority, the Bundeskartellamt, is seated on how to try to bring limits to the ever-growing complexity of antitrust procedures. Another debate that is still playing out right now in Europe is the relation of the existing competition rules, so in particular on the European level, Article 101 and 102, with sector-specific regulation. So in a sense, you could say the Digital Markets Act is to some extent really addressed to certain, not a sector, but certain addressees. And the other question that's going on also with regard to the perceived weaknesses of existing competition tools is and Germany did that, and I will probably spend one slide later on that. In the UK, for example, and that I think that has been the prime jurisdiction on top of the standard competition rules. You have a so-called sector investigation tools where the British authority, the Competition and Markets Authority, CMA, can, without proving an abuse or an infringement of competition law, even opt for structural remedies to remedy a certain competition problem. We have that kind of debate to some extent also on the European level right now. As you know, in June we'll have elections for the European Parliament, and right now is the time when those kind of policy ideas and proposals are sent to the people who will then inside the European Commission set out the new work program for the next 5 years of the European Commission. Then due to all the crises that we've seen over the last number of years, COVID, and then the war of Russia against Ukraine, we've seen a massive increase in state aid in the European Union. As you know, the European Union, on top of the standard classical competition rules, has given itself rules against state aid that would distort competition. And during the crisis years, you've seen basically DG Comp trying to set some limits, but you could see in the face of the Director General of Competition with that he basically didn't get sufficient sleep over the last couple of years because he had to wave through big chunks of state money to save firms. There we have a big discussion between the relation between state aid and competition policy, because of course state subsidies can really distort competition. You could also ask the question, what is a good market structure for state aid to be picked up and used most efficiently in the market? Then we had the huge China discussion. I remember that a former minister of mine, conservative, very pro-industrial policy, was a big supporter of the then attempt of Siemens and Alstom to merge. And he wanted us to give him arguments, and he had discussions with the European Commission Vice President, and now is still outgoing competition commissioner. And at the time, we tried to make the argument to him that given the rules that we have for merger control, it would be wrong to sort of try to now create a European champion, because then in 1 or 2 years' time, we will have a merger by Chinese firms that we can't prevent because it's the EU. We can't just asymmetrically apply the same rule to that kind of situation. Didn't really convince him. The merger was prohibited ultimately. Very strong move by Margrethe Vestager. But what we managed at the time was to say, the root cause of the problem is not our merger rules, but it's subsidies given by the Chinese state to the Chinese player in the market. And that's when legislation, the drafting of legislation started, which is now the so-called foreign subsidies regulation. So what the EU has basically done is, before the state aid rules limited EU member states from giving money to firms. And now we have the mirror side of it, the foreign subsidies regulation allowing the Commission to look into state financing, state subsidies, very similar to state aid control of non-EU countries. And we've already seen the funny irony of history is that the first big case that now came up over the last couple of months was the attempt, a tender offer by CRRC. So that's the Chinese railway producer that played a major role in the Siemens Alstom case, tried to win a tender offer. I think it was either Bulgaria or Romania, undercutting Siemens and another company by a half. So I think it's 300 million offer, European financed, and the others were like 100%. That the price was much higher. And when the European Commission started to ask questions, how these numbers come up, just simply asking, CRRC withdrew from the tender offer. Now, there you can, of course, we could debate later on whether it's good for the EU to take Chinese taxpayer money for some years, go with it, get some product for that, or whether the long-term view in the sense of trying to bring some level playing field, some fairness to that kind of competition. I think that's a big question, also still an open question. Another discussion that we have right now is on economic security, given the geopolitical crises of the last five years. We've seen that in particular for state aid, we see European money poured into industries that are considered important for economic security, like the chips industry, for example. It's probably going to be interesting to see whether we will have a similar discussion like in Siemens Alstom, whether it would be good to have European champions for example, consolidation arms production, maybe chips manufacturing. So that's another of the current policy discussions. A final point, and I guess you're waiting all for the digital markets, is on the relation of competition with non-competition goals, in particular sustainability. For those of you who have followed the European debate on that, we now have new Commission guidelines, the so-called EU horizontal guidelines, that try to set out under what conditions firms which cooperate for sustainability reasons can benefit from some exemption from cartel prohibition under Article 101. That was an intense discussion between the Commission and also the member states. You had more conservative authorities. You had other authorities like, for example, the Dutch Competition Authority arguing for a more pro-sustainability approach. But the guess is that we will see these kind of discussions more in the future. Now, I think I've spent like already 20 minutes on the first slide. I should probably slightly increase my speed. So switching back to digital markets. I think what you've probably all heard is the discussion that started in particular in the EU, I'd say with the Google case, trying to, if I had to pin down what the main underlying problem was, that you have ecosystems, super dominant firms that engaged in trying to and successfully leveraging their power from a core market like search into other markets. Data play a crucial role. And the second big factor was speed. If you look into antitrust enforcement, for example, the Google case in the European Commission, but that unfortunately also applies to many other recent Article 102, so abuse of dominance positions cases, that they just can't cope with the speed of the markets. So we had a long-standing discussion. Some member states basically demanding from to have action from the European Commission. Another factor that I would like to mention before then really going a bit more into the details also of the Digital Markets Act is the European Commission was wise to put at the same time on the table the so-called Digital Services Act that I'm not going to address here. So this is really about content regulation, but I think you can't really, from a political point of view, separate those topics because I'd say that many politicians who look at the big tech space also look at it with the question on what kind of impact and effect they have on democracy, on democratic debate. Now, you could, of course, make the argument that it's not competition that will help us with content regulation, that the more platforms we have, the better our discussion will be. You could make the argument that if you have a good player that sets some kind of standards, that may be helpful on the market. But I would say personally, the right perception is that a competition policy there needs to put limits on the powers of those companies who have a huge lobbying power. I will tell you a bit about the German legislation. That was, I would say, from a professional point of view, the most intense and interesting time I had, because I've never witnessed those kind of lobbying efforts by the companies, even by CEOs calling our chancellor at the time, what are you Germans daring to do here? And we already, we at the time already told them, wait, this is just the beginning. And afterwards, we will see that the DMA is tougher to some extent on the firms than the German legislation. But coming back to my point is that politicians nowadays, I'd say, view antitrust with regard to big tech as one of the potential limits on how to restrain the power. So going back to what I said in the beginning, the initial ideas about antitrust really reining in the power of very, very powerful companies. And I say powerful, again, if you ever work in public service, if you ever work in a ministry or wherever, I assure you that if Google or if Meta wants to talk to your boss, I assure you that those companies will get this kind of access. And that is, I don't say that they are hurt nowadays. There is really a big perception that we need limits on the powers of those companies. But I would really, from the, I can't call it empirical evidence, but at least what I've seen, that they have, of course, this kind of access. Now let me really turn to the legal frameworks and go into the European Digital Markets Act. Now, what the Digital Markets Act does is really doing away with requiring the Commission to set out that a company is dominant. It goes for a designation procedure. So the DMA contains a list of so-called core platform services. You can see the list there. It's basically online mediation services, search engines, social networks, and so on. So it's specifically geared to technologies that we currently see as the most decisive on the markets. Now, you could already say this is one of the downsides of this kind, or the, let's say, the weaknesses of that kind of legislation. Because on the one hand, before, we had just a sentence in the Treaty on the Functioning of the European Union saying the abuse of a dominant position is prohibited. And now we switch to the other end of the scale, or in terms of how regulation looks like. With lots of nitty-gritty detail regulation, we set out the core platform services. we set out the obligations for the gatekeepers that I will present to you in a minute. And the downside of that kind of regulation is really that it may just not be open enough and future-proof enough. And we already see that a bit for artificial intelligence, for example. You might say that some AI functions can be captured under the search engine core platform service. We already see that for cloud computing, which was only inserted into the text at the very last minute by the parliament, where you have cloud as CPS in the text, but you don't have really obligations that really apply to cloud computing. How is the gatekeeper designated? We have certain criteria for that. I've put them on the slides. You can see this is really not about defining a relevant antitrust market. This is really looking into certain specific numbers. And the main reason behind going for that kind of regulation was saving time, getting a result. Just to show you some of the obligations for the gatekeepers. For example, you have now a prohibition of linking different services. You have a prohibition of self-favoring when ranking information. So there is a whole list of obligations that apply to these gatekeepers. The commissioner right now, she's, I think, between a rock and a hard place. She has achieved getting this kind of regulation, but she gets now the pressure from the European Parliament, from politicians to really enforce it and to really change things on the markets. So when you follow her a bit and what she says, my perception right now is that she's trying to play it safely, not to raise too many expectations, because the gatekeepers are pouring in a lot of money into the law firms and the experts. On the slide, you see what the European Commission has so far done. The first designations have been completed in September last year. And the design of the regulation is that after 6 months after the designation, there has to be compliance with the obligations. So Big Tech was given half a year to reprogram, change their business model, and then to submit a compliance report. The European Commission, what can it do in case of an infringement? So non-obligation, you have fines. You have for repeated infringements even higher fines, up to 20% of worldwide turnover. And for systematic infringements, you have additional remedies, even reaching up to the divestiture of business parts. So that's also different to current EU antitrust powers. What have we seen already in March? The European Commission has launched non-compliance probes into 3 gatekeepers, Apple, Alphabet, and Meta. With regard to Apple and Alphabet, it's if you use Spotify, I don't know how many of you do. They have a long-standing battle with Apple about how that Apple is trying to prevent and steer the customers. You have with regard to Alphabet, if you look into your Google search display, a huge discussion going on between who should be on top of the ranking list. I think I could speak for hours on that. And then you have for Meta a probe into the question whether they can offer to you, what they do is basically offer subscription. Either you pay with your data or you really pay in terms of money, just to make it a bit simple. So what's next there? The Commission will have to follow through with the compliance in investigations. The expectation under the DMA, but also politically, is that you have much quicker decisions on whether there is compliance or non-compliance. And that's also, I think, politically the big question on the DMA, because I guess in 2-3 years' time, there will be a political follow-up by the European Parliament, by member states, whether the DMA has achieved its results. Now, switching a bit also into German law. Our reform, the big reform geared towards digital markets, entered into force in 2021. Politically, we tried to persuade the Commission years before that, making the argument that Article 102 of the treaty would not be sufficient to deal with big tech ecosystems. The Commission at the time was skeptical, telling us that they would like to see the outcome of enforcement over time and also in court cases. Our argument was that this takes too much time and will not be ultimately sufficient. So one of the, and we were criticized then for going for national legislation, because in the European Union, I mean, we talk about global players, we talk about at least interconnected markets. So we were criticized for doing national legislation. But one of the main reasons behind it was also to really try to nudge the European Commission to go forward. And I would say I would reduce that for the discussion. I hope that we can still have that. Just to make a bit of allow for a bit of a comparison between what we have under German law now and what we have in the DMA. So we have a specific section now in our national law. At the time, everybody was trying to find a technically sound phrase for gatekeepers. Everybody knew what companies should be addressed. The DMA, when goes for certain quantitative numbers, our language is still geared more towards, or let's say, stuck in the old antitrust world. So we termed them undertakings with paramount significance for competition across markets. And the factors that we used, and we still use in the law, dominant position, financial strength, integration, access to data. And we also have this kind of two-step approach in the law. So the German authority, the Bundeskartellamt, determines whether a company, I was about to say a country, a company has this paramount significance. And then in step 2, there is a list of obligations in the law, which I get there was also some cross-inspiration between the DMA and our section 19A. And one design choice that we had to make is whether those obligations should be directly applicable or whether the Bundeskartellamt has to activate them. And I think we got it right, because we ultimately decided that the Bundeskartellamt has to activate them, because otherwise they would be drowning under cases, courts, and the authority would be really, that's not in the powers and in the resources of a national competition authority to do that kind of job. So the Bundeskartellamt first has to designate, it has designated all the big gatekeepers, and then it really has to address and one by one. Another thing that we did is we only have one court instance. That was also a big battle. So we did away with the first instance. Those cases directly go to the Supreme Court. We now, those kind of procedures can be finished within 2 to 3 years. I think I'm not time-wise go too much into the obligations. What I can say is that right now there are cases against Alphabet on, there have been cases on the Google News Showcase, on Google data processing. And currently there are cases on the service bundling regarding Google Maps with regard to Amazon on its pricing algorithm, brand gating, then also Apple. I don't know whether that's the case here in Turkey, but in Germany, Apple gears itself as very data sensitive and privacy friendly. But what they basically do is they ask customers, do you want to give their data to others? And basically then the default option is no, but basically what the customer then does is giving the data and allowing it that to Google, that Apple can use them. So there we have a bit of a comparison between how the two regimes work. I would say 19A is a bit more stuck language-wise in the old antitrust world. I think the upside that it has, that it's neutral and future-proof regarding technology. It doesn't mention any technology. It can be applied to AI. It can be applied to cloud computing. Now you can, of course, also ask what's the relation? How can you have a national provision while at the same time you have the Digital Markets Act? It was also a bit of a bigger discussion with the European Commission. There is a specific provision in the DMA allowing for some space for national legislation that goes further than the DMA. So there is still room for application for national legislation like the German Section 19A provision left. I think, conclude, and then we don't have that much time left for discussion, to address a bit the missing pieces. I guess you've all somehow followed the rise of AI models. You've maybe also followed how the antitrust community debates the competition, the structuring of the market that is going on with regard to AI models. We have a specific work stream for that for the G7 countries. I think the main slogan there is we don't want to see a repeat of the playbook from the previous years. So there is a strong focus on preventing existing players to leverage their market power into the AI space. If you look what's going on, Microsoft, for example, doing a lot of alliances, for example, with OpenAI, but also with others, where you see agreements that clearly have been designed to sort of circumvent existing merger rules, where you see just a whole department of people moving over to Microsoft. So instances that with regard to traditional merger control regimes, you would really have a problem to capture them. We also see that we haven't seen structural separation that for some markets might be really the best solution. The funny thing is that while the EU has managed to come up with the legislation and in US Congress that has really failed, and there is no additional legislation. My personal guess is that the only jurisdiction that would be able to really go for structural separation, and the DOJ is trying to do that with regard to certain parts of Google Ads, is really the US, but that's then upon US courts. So let me close there. Sorry for overstepping a bit of my time, and I hope there is still some room for discussion.
Thank you. That was great. Thank you very much. Now I turn to you. Start with Kadir. Yes, start.
Thank you for presentation. My question is this: DMA and I think Article 19A both wants to make markets more competitive, creates new competitor, at least eliminate barriers to these competitors. And but I think the big tech company also bring this claim. There is also about concerns about cyber security or data protections. You can create competitive markets, but sometimes this may create problems or concerns regarding data protection, because when you open the competitors, some of them will have less privacy protections, and this creates this kind of problems. I was wondering, in Germany, other than competition, Bundeskartellamt, for data protection authorities, or you may have different maybe department in your ministry for data protection. These people were involved in both designating the companies and also designating obligations. Were they involved in this kind of designation?
A great question. And for example, Apple I mean, you've referred to both security and data privacy. And for example, Apple has, throughout the legislative process leading to the DMA, but also now in the enforcement, said that the obligations that will allow for additional another app store, or to have other apps on the existing app stores, that this will create huge risks for the security of the device. On data privacy, and are these people heard also on data privacy? I think yes, they are on a European level, both during the legislative process and also during enforcement under the DMA. There is a specific committee where also data protection authorities are involved. But you put the finger rightly on let's say, you can discuss that, but I don't think we have perfect solutions there. Because if you want to go for more competition, you will compromise to some extent what, for example, Apple now defines as the status quo of security. Their authorities face the really complex question of discerning what is a valid argument and what is just pretext for not going for another option. And my perception is that the gatekeepers have gambled away a bit the trust in their arguments, because for years they have been dragging their feet without really making a differentiated case for that is really core for security, and this is where we can find other good technical solutions. On the privacy point, that was also a huge discussion in when we drafted our law. In Germany, it's the Interior Ministry that is in charge of the data protection regulation and the national legislation. And of course, when you as a competition advocate say that we need access to the data of, let's say, Meta, to have additional competition on a neighboring market, then you get the counter argument, but how can we keep up data privacy? And I think there the solution is somewhere in between. I mean, that's the way the DMA tries to go, that big tech itself must become more so that there will be probably less good data available for big tech through the classical ways, and at the same time you have access to some data to gear for more competition.
Thank you. Thank you.
Thank you very much for very good presentation. I just wonder, I mean, there are many countries in the world and all these big tech companies operate almost all the same way. So EU and Germany followed with the regulation and very, very harsh regulation, very structured regulation.
Do you think that your amendment in the law is considered as regulation, or is it a variation of traditional competition law?
We would still consider it as a bit hybrid, but still rooted in antitrust. For the DMA, I would clearly say it's regulation, but I totally accept your term. So
I just wonder, I mean, why other countries have not followed the same trail?
Germany?
Germany or EU. I mean, Turkey had some draft, but they just completely gave up. I think gave up, or India or Brazil or something, even the US. They have not followed the same, this harsh regulation. Are they free riders, or do they know something else we don't know? Or some complete policy change between EU and other countries? I mean, I really wonder about this because everybody started at the same point discussing about these regulations and all these matters, but EU followed up and completed their regulation and started their application of the regulation.
You are assuming that the other countries are not changing their laws, or they're not enacting new laws to cope with.
They have not. Most of them, they have not. So they still continue to apply the competition law mostly, rather than this specific regulation cover all market or digital markets.
I think that's really one of the master questions. And my guess would be, I don't have a or not even a good answer. It's really, it's for different reasons. On the free riding, for example, I asked myself with regard to the UK, which is now unbound, and I would have guessed that they don't spend too many resources on that because they say let the EU do the job. But
that's okay.
They chose. But they if you now talk to the people who know the new British regime very well, you see that the CMA managed to persuade politicians to go not for the DMA-like but also for a very stringent regime. So there you see another way of doing it. I'm not so sure whether it's free riding. I would say the US, for example, there it's complicated because the Congress could not really get a consensus. There were I can't count the different draft acts that were on the table, but none of them so far has passed. I'm not so sure. For example, Japan is a bit more reluctant. They are very much focused on what's important for their customers, which is everything that has to do with mobile ecosystems. They went for a specific regulation there. I don't know a lot about the Indian regime, for example, but you might be right that the EU so far is the one that really went farthest. And I mean, there is the discussion about the Brussels effect, both from the positive and the negative side. People, I don't know whether you read the book, but the author who sort of coined the term, seeing it in a positive way. So Brussels is able to change markets also outside its jurisdiction. Then there are the others who perceive it the other way around. The EU always good at regulation, but not coming up with new technology and innovation itself. I don't have a good answer. I'd say that maybe the discussion on gatekeepers' behavior had advanced a lot in the EU. But I'm not really knowledgeable about. I mean, I know a bit about other countries then going for DSA-like regulation. For example, if you look into Australia, they care a lot about their free press and media, so they have a bargaining code caring about. So, but you're right that I think none of the jurisdictions has so far adopted a, let's say, very far-reaching, comprehensive approach like the EU. But I don't have a good answer.
So my question, I was wondering. So the first question.
My counter question, sorry, would have been, what about Turkey?
Turkey, you know, better than we have DSA.
Sorry.
We have DSA, some kind of DSA way, but we have draft for the DMA style regulation, but draft's been there for the last 2 years, maybe almost 3 years, maybe. So they didn't follow in the parliament. Competition Authority drafted DMA style regulation.
We have an amendment.
Similar to German and EU, I guess.
More EU law?
More EU and between the EU and Germans mix. I don't know.
But in terms of characteristics, it's more EU.
More EU.
But we have some provisions similar to that of German law.
Procedural way.
It's like 10-15% of German, the rest is EU type law.
But
so we are more influenced.
I mean, we are trying to rewrite, but I don't know if it works or not. But we have DSA style regulation, more trying to protect the consumers and some kind of.
Can I ask why then Turkey apparently sort of the higher political priority was for DSA, so content regulation instead of competition?
It's like you, I don't know. I wish I know the
Turn off the camera question.
He had more expertise about DSA.
We also target Turkish digital giants, we can say.
Let's say we have quite many companies, dominant positions are Turkish originated companies in several markets. So maybe it could be the reason to protect Turkish companies, I don't know.
But maybe then the flip side is that in the EU, it's actually admitting that we can't get competition, at least in the neighboring markets, to search, to social networks, other than resorting to regulation. For example, when you talk to Japanese officials, they have in Japan, you have heavy competition to Amazon, which we don't have in some EU countries. I mean, Germany, I can't give you the market.
Same situation.
Amazon has only, Amazon only have 3, 4, 5% in Turkey. We have Turkish originated, 2 bigger Turkish originated companies.
It's now owned by Chinese company.
Yeah, one is owned Chinese, but it's still Turkish, but it was originated in Turkey, completely in Turkey. So could be the reason, I don't know.
Sorry for interrupting.
I was going to ask to what extent Germany was influential in Europe, and you already responded that. You said basically German legislation triggered somehow EU legislation on that front. Did I understand correctly?
That would be maybe a bit overstating. There were a number of factors at play, I'd say. I'd say the political dynamics inside the Commission also shifted at the time. You have a commissioner. It's also sometimes down to certain individuals. You had a commissioner like Thierry Breton very successfully pushing for the DMA. And I'd say that the German national legislation at the time was one of the factors that tipped a bit the balance inside the Commission to say, okay, we would like to, and again, I can only say that it absolutely makes sense to have this kind of regulation at the European level because
the resources.
It's a resource question, and it's also a question of coherency, because if we would have 28 member states adopting a Section 19A type legislation, then we would probably really get into a
that was my question. Why did they opt for a more stringent regulation? That was my question, and that's.
So you mean the DMA?
Yeah.
That's really then a second question, I would say, because really the dynamic, I'd say, in the perception of gatekeepers really changed quite rapidly within the frame of 3 years. And the DMA, what we now have as the DMA is to, I'd say, 80–90% the original draft that the Commission tabled. But before the DMA tabled, there was intense infighting in the Commission because...
And this is the year like 2019 or something, 2018?
They tabled it, I think, but don't quote, I think 2019.
Everything was prepared in a very short time span.
It was, the DMA was internally in the Commission like prepared over, I'd say, something between 6 to 10 months. But there were two camps at the time. There was the one that ultimately, I'd say, prevailed. And the other one was pushing for an even more open principle-based regulation that would have given more discretionary powers to the European Commission.
Right.
So there was, to be frank, there was the Thierry Breton side of the discussion and competition people advocating for trying to mimic those obligations a lot to the experiences that they had from previous competition cases. But again, the downside of it is that you have a snapshot of what has happened so far, but whether those obligations will be really future-proof, that's needs to be seen.
You also said that the politics played a role, and it's becoming increasingly important, right? The politics, and there is this counter argument in EU that the reason why they have such a stringent regulation in EU is about the companies that are subject to these rules are US companies, and that's one of the factors that played a role. What do you think about that?
I mean, if that's the question on, let's say, industrial policy in disguise, anti-US bias, I have talked to really a lot of people that were involved in the drafting and now in the enforcement. I can say for all of them, there is no anti-US bias. It's really, I think, the belief. You can call that right or wrong in the sense of overshooting regulation and so on, but it's definitely not an anti-EU bias. I mean, a test case would be that we would really have an EU company then and then with the DMA being enforced against the EU company. But if you look into what DG Competition has done over the years, I would say it's fair to say that overall that has been a fair, symmetric application of rules, both against EU players and non-EU players.
I don't want to monopolize this floor, but one final thing regarding the German one. So you have first designation decision.
Yeah.
That's similar to
yes.
DMA. Then one by one, the prohibitions or the obligations
yes.
are determined.
Yes.
And they are determined by investigation, or they are simply acknowledged and publicized?
It's investigations.
Investigations.
And then you have an administrative decision basically prohibiting a certain space of strategy, certain conduct under these obligations, but that's it. I mean, there is
no fine, no anything.
No.
It's just you have this obligation.
Yes.
And in your slides, I saw a phrase saying that burden of proof is reversed or something like that. And so
that's a bit of a catchphrase. I would say you have situations when under German procedural law, we would use the term non-liquid. So you have facts for and against, and it's like a 50-50% decision. And in that decision, the presumption would kick in, forcing the undertaking to come up with additional evidence on its behalf.
Okay. So when the case is indeterminate, then they have an obligation to come up with some explanation.
Yes.
All right.
What is the time?
So I will have just two questions, very quick.
Okay, thank you so much for coming all the way from Berlin. It's great to have you here. It would be an abrupt change of topic, actually. My question relates to judicial review. I kind of know the answer for Germany because you quickly touched upon. So obviously, naturally, the case law progression is much slower than policy. And I'd say like European Union case law is just catching up with more economic approach when you look at the case law, and there's a tension between like the new aggressive decisions and a European Court of Justice case law. So what role do you think European Court of Justice will play in this transition? Do you think they will, you know, resist, or they will just go with the zeitgeist? So yeah, thank you.
Another great question. So first of all, I'd say in the US, courts are even more important, but the ECJ will play an extremely big role. And my perception so far is that they are a bit, in particular, the Court of First Instance lagging behind, because the CFI has adopted some judgments over the last couple of years that basically tend a bit more towards the more economic approach. So it's really going to interesting to see both the CFI maybe versus the ECJ. And it's also very interesting to see how they will apply the DMA, because if I were the Commission, I would try to now already talk to the court and tell them, this is not competition law. This is regulation. You have to apply a different pair of glasses to look at it, because that's, I think, super important. Because if they start applying their expertise or knowledge from Article 102 enforcement, it will be a disaster.
Okay, thank you for the question and answer. The last question.
Yeah, thank you for the engaging presentation. It was very nice. I'll steal the discussion away from big tech for a moment and revisit what you said at the beginning of your presentation. And I have two quick questions that I believe you can answer maybe as an enforcer, from an enforcer's perspective. Something about FSR. Well, it sure fills in a gap, but the enforcement is limited, and you have to pick your cases. And the way you pick them just has an impact on how the enforcement is going to be shaped.
Yep.
And we are aware of the fact that the resources are limited. So at this stage, I would like to ask, how do they pick the cases? Is it, I mean, is there an impact assessment or some sort of impact assessment, or maybe country by country, maybe by complaints, or some of it, some combination of it? One question is about that. And the other one I'll ask and let you answer both, because it's kind of connected. You mentioned Siemens Alstom. We were mandated to work on the Turkish aspect of that transaction if it would have happened, but it didn't. But in the meanwhile, we had the chance to get familiar with the case. And I was convinced, maybe it was because where I was standing, but I was convinced to a certain extent that the reason that Siemens and Alstom needed to create a European champion was maybe not from competition law perspective, but at least from a competitive perspective, a commercial perspective, was justified. And it may have been right for the Commission to reject that on those grounds back then, but I have not seen any mechanism that would fill the void that Siemens and Alstom raised in their discussions. FSR may be, FSR may help a bit, but so far it has been a couple of years, and structurally, at least I do not see a mechanism that fill that void that would allow European companies to compete on a leveled playing field with their Asian competitors or anywhere else from the world. So how do they bridge that gap today?
Thanks a lot. On the foreign subsidies regulation, the European Commission has a significant resource challenge at the moment, because it has to enforce the DMA, which takes a lot of resources because all these companies throw in everything they have in terms of advice and lawyers. In parallel, they have to build up indeed the enforcement of the foreign subsidies regulation. Now, to be frank, I'm not an insider. I mean, this is really now the European Commission doing its job. The question is very valid, because if you read through the foreign subsidies regulation, the potential scope is super vast. If you could say the DMA is taking on big tech for the world, as you said, the FSR is about taking on every subsidy in the world. So the Commission knows that. I can't tell you whether they will come up in time, for example, with guidelines to try to. My guess would be that right now they pick certain cases. I mean, you have 3 pillars in it. You have a merger pillar, you have a tender offer pillar, and some ex officio instrument. And they will probably pick and choose particular cases to show what the most relevant cases would be. They have to come up with guidelines on what, for example, a subsidy constitutes. But in terms of how they pick the cases, how they use their discretion, I have to be frank, I'm not part of it. And on Siemens Alstom, I guess you mean not standard European champions type of arguments, but more related to the efficiencies. And it's true that merger enforcement over the years probably has looked not sufficiently into the efficiencies of certain mergers, so that you can probably better from your work say for Siemens Alstom. We only got involved at a stage where it was clear that the Commission was on the path to prohibition. And I mean, 2 years later, Alstom was allowed to merge with Bombardier. So at least one champion was created then at the time.
Thank you very much. I think time is over. Thank you, Dr. Käseberg, for your presentation.
Thanks.